ഇതിന് കൗണ്ടർ കേസ് ഫയൽ ചെയ്യും, ഇതിന് ഡിഫമേഷൻ ഫയൽ ചെയ്യും. ഇത് ഡിഫമേഷൻ എന്ന് പറയുന്നത് ചെറിയ ലെവലിലായിരിക്കില്ല. ഇത് ഈ മീറ്റുവിന് ഒരു പുതിയ ചാപ്റ്റർ ആവട്ടെ, കാരണം ഇരയുടെ പേര് പറയാൻ പാടില്ല, അങ്ങനെ ഒക്കെയുള്ള കുറെ ലോസ് ഉണ്ടല്ലോ. ഇവിടെ ഞാൻ ഇരയായതുകൊണ്ടും ഇവര് ഇരയല്ലാത്തതുകൊണ്ടും ഞാൻ ആ പേര് പറയുക.
So, yes, friends, so this is the latest case from the Kerala High Court regarding the famous star Vijay Babu. He's a producer too, and the latest Me Too case. So, one of my learned friend was had started this. Well, here the victim her name has been disclosed, which is yes, of course, when we say that the particular act which prohibits that's the Sexual Harassment at Workplace Act. So here we will be just discussing what the law says. What is sexual harassment? Number one, it is unwelcome sexual behavior that's offensive, humiliating. Please take the words of the Supreme Court. Take the words of the Supreme Court, friends. That is humiliating or intimidating. Sexual harassment of a woman at workplace results in violation of the fundamental rights of a woman to equality and Article 14, which says equality before law and equal protection of law. When we also talk about Article 14, there has to be a mention about Article 15 also, which mention of the Constitution of India, that is a right to life and to live with dignity under the Article 21 of our Constitution. So when we connect all these things, there is a right to life and to live with dignity, and a right to practice any profession. Be careful over here. The word the Supreme Court says is any profession, or to carry on any occupation, trade or business which include a right to a safe environment free from sexual harassment. Now what happens in nowadays, the cases that comes to us women right lawyers are, the men coming running and accusing that, they have been trapped in consensual relationship. So we see that they run to us for anticipatory bail, that in anticipation that there is a relationship which has gone wrong, the woman might file a case of sexual harassment. So these are the things that nowadays, we see as lawyers, wherein the men are tempted to take the name of the woman who troubled them. So it's usually same, women have the right to put their grievances at any platform of their choice, and even after decades, these are the things that in Me Too, you can, I will be just taking an interview of my learned friend, Advocate Nitin Satpute, who initiated this particular Me Too case, and it became a controversy with many women from various fields coming out and, explaining the difficulties that they face in workplace. So it has to be, each and every case has to be taken seriously, and in a matter that, yes, the very aspect of the Supreme Court coming out with definitions and, the actions need to be taken. That is preventive actions to be taken. Of course, redressal, the committee which has to be set up in case of such complaints in any organization. Usually these are not followed. And even when we talk about procedural laws, we teach the Criminal Procedure Code, wherein certain aspects, the evidences need to be collected. In this particular case also, though the man accused, the actor, Mr. Vijay Babu, who has been arrested. So he wasn't supposed to take the name of the woman. Maybe, yes, the men also are in emotional entanglement with the woman. Maybe the relationship went wrong. So evaluation of the law of sexual harassment at workplace. In India, sexual harassment at workplace was for the very first time recognized by the Supreme Court in, yes, the Vishaka versus State of Rajasthan. the Apex Code framed certain guidelines known as the Vishaka guidelines. Now, herein, I would definitely like to mention these are guidelines which are to be, how the committee has to be formed. That is not only the grievances committee, how action need to be taken, how the particular redressal committee, how the redressal need to be, addressed. Specifically, when sensitive matters reaches the court and when they are high profile, it has to be, taken up seriously. So, particular actions which have to be concerned, the guidelines which have to be, the Apex Court, the Supreme Court, the Honorable Supreme Court also issued directions to the Union of India to enact an appropriate law for combating workplace sexual harassment, which has been enacted 16 years after the landmark judgment. So, evaluation of law, pre-Vishaka scenario, the Vishaka judgment, the post-Vishaka scenario. We'll see over here 3 aspects. The pre-Vishaka scenario, the Vishaka judgment, and the post-Vishaka scenario. I will be just speaking to you some important judgments. Now, particularly when a relationship goes wrong, we lawyers see that the women often accuse the man of rape. In one of my case, it was the case of a daughter-in-law fighting against a father-in-law who was a rich diamond merchant. She filed a case against him, a rape, and that too after 2 kids. Yeah, we often go for all this test which proves that, the DNA test which proves that yes, the kids belong to the father-in-law. But then he was granted bail saying that when there are 2 kids, why did she keep quiet? So we can see that in most of the cases, though I was for the woman, I was for the girl, the lady judge mentioned that if it was 2 delivery, why did she keep quiet? And the first delivery, she could have mentioned it. So therefore, the bail was granted. So we see the pre-Vishaka scenario came into picture. The woman had to take the matter of sexual harassment through lodging a complaint under section 354 and 504. 354, assault or criminal force to woman with intent to outrage her modesty. So Indian Penal Code, that was earlier, assault or criminal force to woman with an intent to outrage her modesty. Section 509, any words, any gesture or any act intended to insult the modesty of a woman. So here, this was the laws which were previously there. So you can see the Bhavari Devi. This was, Bhavari पीछे नहीं हटेगी, हम सब उसके साथ है. So you can see this, how people agitated, this was a case of a social worker, very famous. So the Vishaka judgment, I'll just read out the Vishaka judgment. A Dalit woman was employed with the Rural Development Program of the Government of Rajasthan. In 1992, the Rajasthan government launched a campaign against child marriages, in connection with which these members persuaded the villagers to abandon this evil practice of child marriage, which is still rampant in various parts of Rajasthan. So, she was a social worker, Bhavari Devi. So, this campaign she needed to put across to many many people in the villages of Rajasthan. Usually what we do is, now for my PhD also, I had to visit 140 villages of Rajasthan. So my thesis was on domestic violence against women and whether the women of Rajasthan and Marathwada regions are aware of the, intimate partner violence, whether they are aware of domestic violence. So these are the things that is particular social work also. So here Miss Bhavari Devi made all possible efforts to prevent the marriage of a 1-year-old girl, as a result of which the villagers harassed, threatened and socially boycotted her. She sought justice but faced a lot of hurdles from police authorities. The trial court even acquitted the 5 accused. Women rights activists and lawyers filed a public interest litigation in the Supreme Court under the banner of Vishaka to champion the cause of working women in the country. So yes, this is the very, very famous judgment, public interest litigation in the Supreme Court. Friends, yes, the importance of public interest litigations, wherein if any matter arises regarding any woman and her workplace, yes, this was the public interest litigation, Vishaka versus State of Rajasthan. So you can see the main cause of action which was reiterated over here is the sexual harassment in workplace. The sexual harassment in workplace. So in the absence of a specific law in India, the Supreme Court laid down certain guidelines known as the Vishaka guidelines to be followed by the employers until the enactment of an act. These guidelines made it mandatory for every employer to provide a mechanism to redress the grievances pertaining to sexual harassment at workplace. Extremely careful over here is it's mandatory for every employer to provide a mechanism. Why the mechanism is needed? To redress grievances pertaining to sexual harassment, which is rampant. It is rampant, friends. As lawyers, we are seeing many cases, many complaints coming, especially in workplace wherein people become intimate with each other, they become emotional, and such stuff wherein then the Sexual Harassment Act take place. So Vishaka guidelines were to be treated as a law declared in Article 141 of the Indian Constitution. Now, in framing the Vishaka guidelines, the Supreme Court placed reliance on the Convention of Elimination of All Forms of Discrimination Against Women, which was both signed and ratified by India. Now, as I said, Article 14, that is equality before law. Equality of law and equal protection of law. So, the Convention of Elimination of All Form of Discrimination Against Women. So, she should not feel that she has been humiliated, or just because she is going to a workplace, she has to accept all the conditions that is sometimes, actually truth in certain industries. I don't want to mention the industries, but women from all sector come to us. Maybe the corporate sector. We handle many cases wherein women from corporate sector also coming across. So as per the Vishaka judgment, issued under the Article 32 of the Constitution, would have the effect of law and would be mandatory both in the private and government sector, friends. Both in the private and government sectors. So post Vishaka, we see some other judgments, that is Apparel Export Promotion Council versus A.K. Chopra. The Supreme Court reiterated the law laid down in Vishaka and upheld the dismissal of a superior officer of the Delhi-based Apparel Export Promotion Council who was found guilty of sexual harassment of a subordinate female employee at the workplace. The court enlarged the definition of sexual harassment by ruling that physical contact was not essential for it to amount an act of sexual harassment. So friends, over here, physical contact, the Supreme Court reiterated the fact that yes, physical contact is necessary. Just a sort of harassment for maybe promotional, maybe getting a role in films that she is being utilized, or maybe she feels that she has been utilized. Maybe there was an emotional attachment, maybe she was promised a role, and maybe promised marriage. So all these are the instances which we lawyers get nowadays. We say modernization, but we say that in modernization we say equality, women are claiming equality, but in this race of equality also we see various cases where men are wrongly accused also. Maybe the emotional string which was attached in the relationship went wrong, and she feels that she was used, or maybe she was misused. So these are the things where under the procedural laws the court need to frame a judgment wherein a particular case has to be considered in a different way. Now, Medha Kotwal Lele versus Union of India. Here, Dr. Medha Kotwal of Alochana and NGO wrote a letter to highlight a number of sexual harassment and cases and stated that Vishaka guidelines were not being effectively implemented. The Supreme Court converts the letter into a writ petition and took cognizance and directed the state government to file affidavits emphasizing on the steps taken by them to implement the Vishaka guidelines. Now, yes, friends, we as lawyers see that most of the organization doesn't follow this particular norm. Only when a particular case comes up, suddenly, they form a committee and suddenly the file comes out and suddenly a lawyer is invited and, come on, how do we address this issue? So after not being satisfied with the implementation of the guidelines, the Supreme Court directed the states to adopt sufficient mechanisms to ensure its effective implementation of this particular law. The Supreme Court also asserted that in case of non-compliance of the Vishaka guidelines, the aggrieved person can approach the respective high courts. So yes, the victims can approach the respective high court. So here also we see that wherever a victim, usually I said in so many of our cases, the police, they say that this was consensual, so this, that, sometimes the DNA report also doesn't come to the court on time. So in one of my particular case wherein I told you the daughter-in-law, she had accused the father-in-law of rape, 7 years of sexual harassment at the marital home. Here also it was very difficult for us. Then finally the court had to put up a mediator, and then somehow we had to close the case because she was in a way she was like wanting to get remarried and settle abroad. So these are the things, that particular case, they then withdraw in later on stages. So finally the men also suffer. When women have agreed, So there are draft protection. So we say that April 23rd, 2013, the POSH Act received the President's assent, was published in the Gazette of India. December 9, 2013, the Indian Ministry of Women and Child Development notified on December 9, 2013 as the effective date of the POSH Act and the POSH rules. So prevention of sexual harassment. The bill was passed by the Rajya Sabha, and the POSH Act received the President's assent and was published in the Gazette. So we can see that we have now a strong law. And in my next video, I will be 100% giving you the detail pertaining to the guidelines reflected in the Vishaka judgment and some of the cases that we lawyers handle. It's very sensitive, therefore it's but natural that a woman's name should not appear. So it is, we will be just doing this 8 chapters in 30 sessions. So how we will be, speaking about the order of a woman to claim protection under the Act. The incident of sexual harassment should have taken place at the workplace. So thank you, friends. Just go out for the next video on what are the precautions to be taken pertaining to the particular Act, the Vishaka guidelines.